Hey guys, welcome back to today's video. I've got 3 clips lined up for you, all featuring sovereign citizens at very different stages of dealing with the law. The first guy is currently out on bond. The second is already in jail awaiting his hearing. And the third, well, he confidently believes bailiffs can't lay a hand on him and quickly learns otherwise. Let's jump right in.
And Your Honor, I believe that the individual remaining in the courtroom would like to introduce himself to the court.
Hello, my name is Colton James, family name Wlin. I'm here today by special appearance solely to address discovery and clarify matters from the previous hearing. I am not submitting to the court's jurisdiction for any other purpose and preserving all objections related to jurisdiction. At my last appearance, I was under the impression that there would be no plea entered and the papers would reflect that, as well as me maintaining my innocence, including my constitutional right to assert my innocence. I want to reaffirm that I am maintaining my innocence.
If you want to make a statement on the record here, because we are on the record in court, you have to speak into the microphone so that it can capture your words.
Is this on the calendar? I guess I'm just confused as to what
it is. I want to get to that.
Where's the microphone?
It's sitting at council table right there.
Okay. Would you want me to sit or?
Yes.
Okay.
Let's start again. What is your name, sir?
My name's Colton James, family name of Wlin.
Wlin. Colton Wlin. Cause number 5A0561-562 and cause number 5A0561-563. Mr. Wlin, I see that we're here for a pretrial hearing. Let me hear from the city first.
I do not believe that Mr. Wlin has gotten an attorney yet, and don't know if he wants one. I believe he mentioned at the last hearing that he wished to proceed pro se, but that's not really something in the control of the city.
Okay. So first things first, Mr. Wlin, you need to be represented by legal counsel, or you need to represent yourself. Would you like to apply for a public defender, or would you like to hire an attorney of your own?
I wish to be here at present as myself.
I can see that you're here at present as yourself. What I'm asking you is whether you would like to be appointed a public defender, or whether you would like to hire an attorney of your own.
I wish to do neither.
Well, so, Mr. Wlin, you're not allowed to appear without counsel unless you are asking the court to approve that you be allowed to represent yourself in pro se.
I thought my right was the ability to represent myself.
It's both true and not entirely true at the same time. The Sixth Amendment to the United States Constitution guarantees your right to legal counsel, but it doesn't explicitly state that you have the right to represent yourself. That interpretation comes from the Supreme Court's decision in Ferretta v. California, which held that the right to counsel also implies a right to self-representation. But there's another side to that ruling, and we'll get into that in just a moment.
No, it is not. You have the right to legal counsel at any criminal proceeding. You can be provided a public defender free of charge if you qualify financially, or you have the right, of course, to hire an attorney of your own. If you qualify in terms of what the legal requirements are to represent yourself as your own legal counsel, you may do that. I don't recommend it, but we can go through that procedure if that is what you are requesting.
Would I just be able to get a continuance then at that point? Because I need to brush up on a few things so that I may accurately defend myself.
I'd hear from the city if Mr. Wlin is making a motion to continue. He's not currently represented.
Your Honor, I don't have an objection to the continuance. I don't think we need to do a colloquy today. It doesn't sound like he's quite there where he's necessarily waiving. He's still making that decision. City doesn't have an objection. We would need a speedy trial waiver. I believe Speedy's running well, actually, let me check if it's running from today or if it's running from sorry.
So I see two cause numbers according to Jabs. Pleas of not guilty were entered on the 28th of August.
Which was a misrepresentation of what my intentions were, which is what I also wanted to talk with the court about.
Your Honor, the docket makes it very clear the defendant stated he is innocent of the above charges. That's what was discussed last time we were here. He seems to be rejecting the terms used in this court, but he made an innocent plea on 8/25, and it does look like we would need a speedy trial waiver if there was going to be a continuance today.
I do see that in looking at the court's record, Mr. Wlin, it states that you stated that you were innocent of the charges, which is not the language that we customarily used, but if you are not pleading guilty, you are going to be pleading not guilty. There is no third option. That said, it was noted as entered back in August, not guilty pleas to both charges, which preserve your constitutional rights to trial and everything else. We will hear your request for a continuance today. If that's what you want, I'm prepared to grant it. Counsel for the city has reminded us that the speedy trial requirement, that is to say the time requirement for you to be brought to trial constitutionally under the state of Washington's laws, requires you to waive that speedy trial if you are asking for more time, because a continuance would take you out beyond that.
Okay, just out of clarification, so the Sixth Amendment does not give me the right to represent myself?
I am not your attorney, Mr. Wlin, and I am not attempting to give you legal advice.
But you are saying that I have to ask to represent myself when I believe that the Sixth Amendment right is the ability to represent myself as like a constitutional right. So I'm asking the court on why that it's not really being allowed in this situation.
It's not that you're being denied the right, it's that you haven't completed the legal process required to represent yourself. As mentioned earlier, the Sixth Amendment to the United States Constitution is interpreted to include a right to self-representation, but that right isn't automatic or unconditional. The courts also rely on key rulings like Godinez v. Moran and Indiana v. Edwards. In Godinez v. Moran, the Supreme Court clarified standards around competency, while Indiana v. Edwards further explained that someone can be competent to stand trial, yet still not competent enough to represent themselves. In other words, the bar for self-representation can be higher, and courts have the authority to require legal counsel if a defendant cannot adequately handle their own defense.
I am not engaging in a colloquy with you about whether or not you're qualified to represent yourself. I think that the court will be willing to do that if you indicate, in fact, that you do want to do that. I had heard that you were asking for a continuance in order to better prepare, which frankly is a good idea.
The continuance was only due to the fact of you saying that I wasn't able to represent myself or act, for myself, defending myself. If I am able to, then I would like to continue and we can go. But if not, then a continuance would be in order so that I can revisit a few things.
So to take the first issue first, Mr. Wlin, you are not constitutionally guaranteed the right to represent yourself in court. You are constitutionally guaranteed the right to have an attorney represent you. If you wish to represent yourself in court, the court may engage in what is known as a colloquy with you at a later time, that is to say, not today, in order to see if you are qualified to competently represent yourself. That's something that can take place at a later date. The court will hear your motion to be qualified as a pro se defendant. I also heard that you are asking the court to continue these cases so that you can have time, presumably, to prepare for that colloquy, if that's what you want. I'm prepared to grant it. I will tell you, though, that I cannot grant it if you do not wish to waive your speedy trial right, because your trial is currently set. Pardon me, it's not set, but we have speedy running when?
From the 28th of August.
It would take us sometime into next month. How much time are you asking for as a continuance, Mr. Wlin?
Well, honestly, I only came here by special appearance to assert innocence and request discovery. But given the matters that
Your not guilty pleas have already been entered at your last court appearance.
which I didn't want to plea or contract with the state or city of Bellingham, which was the issue at hand. I just wanted to maintain my constitutional right of innocence. Is
Your constitutional right to a trial and the presumption of your innocence, as well as your right to an attorney and all of the other rights that were discussed, are maintained.
I'd like to maintain all rights and not just the ones discussed.
Despite your objections, the judge is actually preserving your rights, not denying them. You will have the opportunity to represent yourself, but the current substitute judge is choosing to wait for the presiding judge to return before conducting your colloquy, the formal process where the court ensures you understand the risks and responsibilities self-representation. Once the court verifies that you have the necessary cognitive ability to competently handle your own defense, your request to proceed without counsel can then be properly granted.
I would like to maintain your rights as well, Mr. Wlin. I'm asking you, as to your speedy trial right, which is a rule of court here in the state of Washington,
Okay.
if you're asking for a continuance, you need to tell me whether you want to go to trial before November 28th, or wish you'd rather to continue until after that date.
We can go before if you want.
I don't have any position in the matter, Mr. Wlin. You're appearing before this court.
I'm fine with that.
And
You're
Your
fine
Honor,
with what?
With
Perhaps-
going before.
perhaps what might make sense is if we just set it over without a speedy waiver, do a very short set until the presiding judge is back and can go through the colloquy, perhaps a week or two.
Certainly, I'll say that, Mr. Wlin. We can continue your matter inside of the time remaining for the speedy trial requirement.
Okay.
But it will be a very short amount of time to prepare for trial if that is what you wish to do without waiving speedy.
That is fine, as long as I am able to pick up my discovery today at the end of court. That'd be totally fine with me, because they have not done their obligation of submitting it to me by CRR 4.7.
So, Mr. Wlin, as I understand it, you do not have counsel appointed or having made a notice of appearance in this case.
I'm notice of a special appearance, yes.
And you
Your
have not.
Honor, the city will follow the rules for discovery for criminal procedure. Soon as we get a request for discovery, we will comply with it within the time frames that we're required to.
Thank you, counsel.
Your Honor, what I understand the preference, but CR 4.7 allows I'm preserving my rights while requesting discovery, and the continuance I'm obligated to have that, not necessarily by written. So this would be my formal request.
The city has indicated that they will follow the court rules regarding discovery, Mr.
Okay.
Wlin.
And can I pick it up today?
No.
Okay, tomorrow? Monday?
Mr. Wlin, you'll address the court while you're sitting before the court.
Okay.
I'm trying to recall the rule of court that requires presence in person or virtual or via counsel. And I believe
3.4.
3.4.
it's 3-4, yes.
And just as clarification, this is the omnibus hearing, right?
No, it is not.
It's a pretrial?
That's correct.
Okay.
Mr. Wlin, we have a court appearance that we are setting in your two cases. As I said, you are to appear timely. You are to not violate the criminal law of the state of Washington. You are to update any address changes with the court and with Department of Licensing. You are to only use your true legal name and date of birth to identify yourself to the court, and you are not to drive without a valid license or proof of liability insurance. I have noted on this order that the defendant has requested a continuance. He has noted that he does not wish to waive speedy trial, and he has requested to represent himself in pro se. Arraignment having already been accomplished here, not guilty pleas entered and probable cause found. I don't think that there's anything further.
Just promise to appear. He just needs to sign a promise to appear.
Okay. Mr. Wlin, the promise to appear is before you. When you sign it, we will have a copy made for you so that you can take it with you.
Okay. What about the discovery?
Drop the attitude and pay attention to what's actually being explained to you. The prosecutor is telling you there's a proper legal process for requesting discovery, and the judge is making it clear that court rules apply no matter what. Whether you choose to represent yourself or have an attorney, you're still required to follow the same procedures and standards as everyone else in the courtroom.
The parties to this litigation are bound by the Washington Rules of Court, which govern production of discovery documents. Counsel for the city has indicated that they will follow those rules, and I have no doubt that they will.
Okay.
Your attorney, or you, if you represent yourself after you have been allowed by the court to represent yourself, can make a request for that discovery, and it will be responded to.
So I do understand the preference of making the request. However, it is up to them to be. It says the CR 4.7 says the prosecuting attorney shall disclose to the defendant.
Mr. Wlin, you're not an attorney.
No,
you
but I'm
don't
just
represent
asking you,
yourself
I'm
right
asking
now
you to
today.
have them.
You don't
you know.
represent yourself. You have not been allowed to represent yourself yet. You have the right to have an attorney represent you, and one can be appointed to you if you want, and you qualify. Now, if you want to request that the court allow you to represent yourself as your own attorney, that is a legal procedure known as a colloquy that you can engage in. I heard you ask for a continuance so that you could prepare for that, and I granted it. I cannot give you legal advice, sir. I can only tell you when your next court date is and what the order of the court is.
I'm not asking for any legal advice. I'm asking for them to at least, be obligated to give it to me without the referral request or the written request.
Your Honor, it requires a written request. 4.7 requires a written request. If we get one, which can be as simple as emailing, you can email me, which is megood@cob.org, and I will make sure that request, that discovery gets to you.
So I have to ask you for your obligated
Mr. Wlin,
obligation.
address the court when you're sitting before the court.
So I have to ask them, outside of the court, for their obligated duty to fulfillment.
You're required to follow court rules even if you choose to represent yourself. With that hearing now concluded, I'll be keeping an eye on his next court date, which should be coming up in the next couple of weeks. Now, let's move on to another sovereign citizen. This one somehow managed to get himself trespassed from a public park and then arrested shortly afterward.
All right, then do we have Mr. Moola here? Excellent. This is case number 25M 1-0. I understand, Mr. Sullivan, that your office might have a conflict with this case.
Yes, Judge, and I believe it was filed with the court.
Okay. So let me unmute Mr. So good afternoon, Mr. Moola. This is Mr. Sullivan. He's here with the Office of the Public Defender.
Yes.
They have a conflict with your case, so if you remain in custody, I'm going to appoint a lawyer to represent you.
I represent myself, ma'am.
Okay.
It's a right. So
Sure.
I represent myself. Yeah.
Thank you. I don't need you to advise me of the law, sir. But if you'd like to exercise your Sixth Amendment right to represent yourself, you may. Let me hear the people's bond argument, and then if you'd like to make an argument, you may. I'm going to mute you while they do that. Thank you. Ms. Mayfield, what is your argument regarding bond?
Your Honor, I don't think I have an argument under 164113.
So I'm not sure if you do you know what happened yesterday?
Maybe not.
So, yesterday, Mr. Moola appeared in Division 7 and was extraordinarily disruptive, using very foul and offensive language, very obstructionist behavior in the courtroom, failing to adhere to court orders, to appear at the lectern, essentially failing to adequately identify himself. What I'm going to do is allow you to make any argument you'd like to make, Mr. Moola, and then I'll make a ruling regarding bond.
Yes, ma'am. I was illegally detained on a bench warrant that was issued while I was in a courtroom for a non-appearance. So, yes, I got irritated. I know my rights, ma'am, and I have the right to travel in regards to the first trespass charge. So also I work with the homeless community here.
Okay.
I work with all the programs.
Okay. If you could wait just a sec, what I'm going to do is ask you questions under the statute. I'm going to ask you questions under each subsection. Don't talk about the allegations, okay? So what is your full name and date of birth?
I'm Johnny Lay, free and living man, all rights reserved.
Living? Sure. Free? Not so much. And it's hard not to notice the recurring fixation some sovereign citizens have on declaring themselves living people. It comes across like they're trying to assert a legal distinction that doesn't really hold up in court, almost as if simply stating they are living somehow separates them from the legal system, when in reality, it changes nothing about how the law applies to them.
In the event that the court were to release you on a personal recognizance bond, would you sign that bond?
Yes, ma'am.
Okay. Let's see. What are your ties to the jurisdiction?
To the jurisdiction.
To Boulder
I've
County.
been here for 2 years, seeking sanctuary, and I've been bullied and targeted and harassed by cops and other organizations since I've been here for helping the homeless.
Okay. And just wait. Ms. Mayfield, you said you don't know of any record you could make under E or F.
I do not.
Okay. All right, Mr. Moola, was there anything else that you wish for me to know before I address your bond?
Nope.
All right. Okay. What the court is going to do is authorize a $1,000 co-signed personal recognizance bond, no contact with the victim, pretrial supervision.
And who's the victim?
Let me take a look. Mm-hmm.
And what are the charges? I didn't hear any charges. So.
Yep. So let me tell you, you were, I think, issued a summons, but let me take a look. Yes, you were. And so when you were issued the summons, the
I don't have an
charge.
address.
Oh, just a sec.
I live in a car.
Somebody likely handed it to you, but let me take a look. And how about we do this? I don't interrupt you and you don't interrupt me.
Sure.
All right.
Thank you.
You're welcome. Yep, it looks like the officer tried to hand you the summons, but you refused it. So let me share with you what the charges are. You're charged with the unclassified petty offense of third-degree trespass and the Class 2 misdemeanor of obstructing a peace officer. As it relates to the address you are alleged to have trespassed,
Kevin G. Fine.
well, do you see that, Ms. Mayfield? That it's Evan G. Fine? Oh, here. Oh, yep, it is. So when I say no contact with the victim, it's Evan G. Fine.
Okay.
Okay? You asked me what that was. So now, let me tell you.
Can I ask a question when you're done, ma'am?
You may ask that question right now if you would like.
How is a public space a victim?
So you are trespassed from that area, and so what I'm saying to you is no contact with Evan G. Fine Park.
Well, the officer that I had initially interacted with said that it was only during the hours of 11 to 5.
Right. So from 11 to 5 and then 5 to 11. In other words, you've effectively been trespassed. So for now, don't go back. That wraps up that hearing. It was just an arraignment, so a future court date has been set, and I'll be sure to cover it if it comes up. Now, before we wrap things up, I came across another wild clip featuring someone who confidently tells deputies they have no authority to arrest him, just moments before they do exactly that.
This is 25 CR 3889. Mr. Gavin appears out of custody here for a first appearance. There is one formal charge that's been filed. And Mr. Slocum, do you have a copy of that complaint information?
And I'm sorry, was this Mr. Gavin?
Yes.
Okay.
And so this is a copy of the complaint information. So hang on to that. It has some limited information about the charge that was filed and your case number. Mr. Gavin, are you planning on applying for the public defender's office?
No, ma'am.
Okay, you're planning on hiring a private attorney?
No, ma'am.
Okay, you're just going to represent yourself?
Yes, ma'am.
Okay.
Okay.
All right. Well, Mr. Gavin, do you have any legal training?
No.
Okay. Have you ever filed a motion for, okay, have you ever had a motions hearing?
I'm not illiterate, Your Honor.
I'm certainly not implying you're illiterate.
I feel. So can we please approach?
Okay. No. So my concern is that you want to represent yourself, and it's not that I'm implying you're not intelligent. What I'm trying to just advise you of is that the legal system is really hard to navigate and it's very complicated.
Your Honor, I understand, but that has nothing to do with me, Your Honor.
Okay. All right. I'm going to give you an advisement here. It's called an Arguello advisement. And it's required for individuals that want to go forward pro se and represent themselves. I want you to know that you have the right to counsel. You can hire a private attorney, apply for the public defender services and see if you qualify, and then one would be appointed at no cost to you. Do you understand that you have the right to be represented in this proceeding?
Your Honor, is there a bond on this?
Sir, if we can't get through an Arguello advisement, then I can't continue your case. So we're either going to get through this advisement or I'm just going to keep setting you over until we do. So what would you like to do? Go through the advisement so that you can then represent yourself and your case can move forward?
Your Honor, is there a bond on this case?
You're out of custody, so you've posted a bond if there was one.
Is there a social security on this case?
I don't know what that means. A social security what?
My social security number.
Yes, your social security number is associated with you in this case.
Right, so it's tied to all my charges, correct?
Your social security number?
Yes.
If it's associated with you and you're associated with this case, then I would assume it's a part of...
So I am the beneficiary, correct? And you are the fiduciary. You are the servant of the state.
She serves the public, not some imaginary estate. But in this moment, she's about to deliver some very real and very bad news to a member of that public.
So, Mr. Gavin, you have an active warrant in another case. In 21 CR 5803, there was a failure to comply warrant that was issued on September 5th. And there's a no bond hold. So you're gonna be remanded and go into custody on that case. And what we
September 5th, I was in custody.
That's when the warrant was issued.
I was in custody, ma'am.
That very well may be. So the warrant was issued on September 5th, advising that you failed to comply in 21 CR 5803. Having an attorney would certainly help you understand everything that's going on. Either way, you're going to be remanded on that case. And then this case is going to...
The bailiff can't touch me. That's illegal for the bailiff to touch me. You're a servant. You're a deputy sheriff, either or. You're not allowed to touch me.
That's not how this works.
How is there a warrant? How is there a warrant for someone in custody?
So I think what I'm going to do with this case, I haven't gotten through an Arguello advisement, but I tried and it doesn't seem like we're going to get there. So I'm just going to send it to Division 8. We'll set it for an arraignment there. We'll make a note that Mr. Gavin is wanting to represent himself and that he still needs an Arguello advisement, and Mr. Judge Bentley can work on that. And then Mr. Gavin will be remanded on 21 CR 5803 in that court.
I'm not going to be remanded for something I didn't do. I was already in custody.
It doesn't matter.
It does matter. How do I get another charge if I bound?
I
bonded.
Listen, I could explain this
I
to you, but
bonded
you're
out,
not,
Your Honor.
so I can't explain
Your Honor,
it to
I
you.
bonded out.
On this case.
Yes, there was
I'm
no other
talking about
case.
a different case.
How do I have another case if I'm already in jail?
It's 21 CR 5803.
25, excuse me?
21 CR 5803.
And what is this under?
This is a case.
What are the charges?
Probation case. So that's the case you're on probation for.
I'm on probation on all the cases.
You're already on probation for other cases, and now you've picked up a new charge, which is a clear violation of the agreement you made with the court. That's precisely why those officers are calmly positioning themselves behind you. They're preparing for what comes next.
Because I'm already on probation, Your Honor.
Not in this new case. This is your old case that you're on probation for.
But I was already in custody.
I understand that on this case, and you bonded out on this case.
I bonded out.
And then there was a warrant issued on your.
How was there a warrant?
Because there was a failure to comply based on this new case. When you're on probation, it's a violation of your probation to get charged with new cases.
Okay, so what is this number again, please?
Mr. Gavin.
Can I get this case number?
She said it.
I'm trying to write down this case number.
Sorry, I've given it to you multiple times. I can't help that you're not listening to me.
I'm just trying to put this, man. Damn it, every time I come up here, y'all trying to put me in here, man. I'm tired of you, Honor, too. You're just a servant here. I'm not resisting.
You are resisting.
Man, you trying to hit me on a pin cap, dog.
Resist. With your hands behind your back.
I have my hands behind my back. You guys are overreacting. Definitely. Because I can slam all y'all.
Stop resisting.
I'm not resisting.
You are.
How am I resisting, Martinez?
I don't know who Martinez is, but I'm not.
Well, don't know. How am I resisting? Just bonded out. See, I try to play the game and bond out to take people's money, right?
That's all perfect. Let's do it. All right. All right.
These are my things.
Yeah, we'll grab your things.
I have my information, correct? Public servants shouldn't be able to do this. You're like citizen that's solid.
Now how are we gonna?
Alright, that's a wrap on today's video. Honestly, there's no better way to kick off the weekend than watching 3 sovereign citizens completely unravel, both in court and in real life. If you enjoyed the video, make sure to hit that like button, drop a comment with your thoughts, and subscribe for more content like this. I'll catch you in the next one.